In a hearing about whether a doctor engaged in professional misconduct below the standard of care, is it legally insufficient if an expert relies upon guidelines outlining what the standard of care is? To find out, you have to read Matter of Wan Yi versus New York State Board of Professional Medical Conduct. But it's 8 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Matter of Wan Yi versus New York State Board of Professional Medical Conduct. The citation for this case is 2025 New York Slip Opinion 03103, published by the New York Court of Appeals on May 22nd of 2025. The issue in this case is whether at a hearing to determine whether a doctor has engaged in professional misconduct, does the fact that an expert against that doctor relied in part upon published guidelines by a professional organization, does that render his testimony basically inadequate to sustain the charges of professional misconduct? To understand and appreciate the context of this case, what you have to understand as background is that in New York, professionals such as medical professionals, doctors, dentists, psychiatrists, all kinds of different doctors have to practice up to at least a minimum standard of care. And that standard of care is set by the profession in general. What would a reasonable practitioner in the position of the subject, how would they have acted? What kind of care would they have exercised under similar circumstances? And if they fall below that minimal accepted standard of care, they can be charged by the New York State Board of Professional Medical Conduct with disciplinary action, with being substandard, with gross negligence, with different kinds of charges that can ultimately result in fines, losing license. Basically, losing license is the biggest charge the biggest punishment they can give for misconduct. But importantly, with respect to that area of law, with respect to professional misconduct claims, professional organizations do not. There's a case called Diaz versus New York Downtown Hospital, which was a New York Court of Appeals case, which held that professional organizations alone cannot issue recommendations or guidelines that determine the standard of care. That can't be the basis alone. You can't say, well, this particular organization published this article or this standard of care, and the subject in this case, the doctor, failed to meet that published guideline, and therefore he is substandard. That cannot be sufficient by itself to sustain a charge of professional misconduct. So what are the facts in this case? The facts are that the defendant in this case, the petitioner here, the subject, was first licensed to practice medicine in New York in 2006. He was a board-certified radiation oncologist and director of a private radiation oncology practice. In 2018, the New York State Board for Professional Medical Conduct charged the petitioner here with 17 specifications of professional misconduct, including practicing medicine with gross negligence, gross incompetence, negligence on more than one occasion, and incompetence on more than one occasion. They stem from treating 7 particular patients between 2009 and 2013. The allegations in general allege that he used too much radiation for the particular patients in question, right? That he used too high a dose, that he was using cure amounts of radiation as opposed to palliative doses of radiation. So at the hearing, the board called an expert witness to testify about the treatment rendered by the subject, and that expert witness from the board testified that the subject fell below the standard of care with respect to his treatment. But in mentioning the standard of care, when on cross-examination, he said, look at these guidelines. He says, we have accepted guidelines that are published by multiple societies. They include our board, the American College of Radiology, the American Board of Radiology, and National Comprehensive Cancer Networks. And these are fairly prescriptive guidelines for what a physician should do in the management of cases in very specific areas. When you deviate from these, this is what he said, when you deviate from those, it is considered to fall short of a standard. Now, that witness also testified that he had 30 years of experience in the field, that he had treated patients in similar circumstances, and that he identified the treatment given to the particular patients as below the standard of care. The board then upheld or sustained a charge that he was negligent, that he engaged in substandard treatment, right? Care that was below the standard of care required. The subject then appealed to the appellate division saying, wait, this was improper because he relied upon guidelines and that is not allowed by that Diaz case. The appellate division, upon review of what the hearing had done, said, no. He talked about a lot of different things. This was one link in the chain, not the entire argument that he made, and they sustained the charges of misconduct. It goes to the Court of Appeals. And here the question is, before the Court of Appeals, does the fact that the expert relied upon by the board, does the fact that he cited to those guidelines and said those failing to meet those guidelines falls below a standard of care, does that taint his entire testimony? Does that mean that the conclusion is not allowed to be relied upon by the board? And the Court of Appeals says, no, it does not mean that. They say, first of all, the Court of Appeals says we have to uphold the determination of the board if it's supported by substantial evidence. And in this case, it was. They say the fact that he relied in part upon the deviation from the published guidelines is relevant and interesting, but he also relied upon the fact that he had 30 years of experience, and it should not be viewed in isolation. That testimony that I cited before should not be viewed in isolation. The board's expert was well credentialed and had over 30 years of practice experience. So he cited to that as one reason why he found misconduct here, but it was not the entirety of why he found misconduct. And so there's substantial evidence, and the board's determination was upheld. And that's the case of Wan Yi versus New York State Board of Professional Medical Conduct. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.